Welcome to the session on the Trade Union Act 1926. As you know, formation of trade union is it is a global affair. It means that almost all the countries, the trade unionism is prevailing. Because trade union basically, it is considered as one of the rights of an employee to form in the form of the association or union to take up their grievances or to address any issue related to the workmen with respect to employers. This has been accepted a global fact. In fact, the ILO also has accepted and then they are promoting the formation of union and associations across the globe. ILO has played a prominent role in spreading the message to say that employers should not come in the way of workers or employees forming union or association in his behalf. They must be given encouragement. This is the kind of message what we mean by ILO. Every country has got its own history of development of trade unions, the background, how it came up, what happened. Every nation has got its own history. In India also we have our own history to start the trade union movement in India. You know that 1851 and 1855, this is the start of the modern factory system in India. It started. After 1981 and 85, large number of factories came up, and at that time, as we discussed in Factories Act, there was no law to protect the interests of workers, and lot of insecure feeling was there. Working conditions were very, very pathetic, particularly employment of children and women. So this created a lot of discontentment amongst the working lot, even at that time. At that time, Mr. L.K. Dhyani, who took the initiative, and in fact, he collected signatures of almost about 13,000 workers at that time, and then submitted to the government factory, or the Secretary of State, India. He gave the representation, and as a consequence of that, the Factories Act came into being in 1881. But unfortunately, again, that did not meet the requirement of the workmen, and again Mr. Pandey has to reconvene, and then he collected signatures of more than 5,300 people, and then started collecting signatures and then drew up a memorandum. Actually, this is the beginning of the modern trade union movement in India. In fact, the moment submitted and adopted this meeting demanded the weekly rest, half an hour recess, compensation for disablement, payment of wages for not less than 15 days in a month, following the one which they were earned, limitation on working hours from 6:30 a.m. till sunset, all these things submitted. Then in the meantime, Bombay Mill Hands Association and other labour unions also formed after 1885. However, what happened, the conditions did not improve, even in spite of all these things. Another representation submitted by almost about 17,000 workers in the same year submitted a memorandum. In fact, at the same time, Bombay Mills Hands Association also established under the presidency of Mr. Lokhande. So another factory commission was appointed in 1884, and Mr. Lokhande organized a campaign of 5,300 representing and presented to the factory commission. This is the beginning of modern trade union movement in India. Even the memorandum submitted, adopted this meeting, demanded many facilities for the workmen at that time. Bombay Mills Hands Association and other labour unions. However, what happened, the conditions did not improve in spite of all these things. Hence, another representative submitted to the government in 1890, reiterating the demands of 1884 and signed by almost about 17,000 workers. In the same year, Bombay Mill Association was established under the presidency of Mr. Lokhande. This is the first labour association in India. The Bombay Mill Association may not, however, be classified as a junior trade union. The workers did not have any effect, any organization of their own. In the meantime, large number of trade unions started after 1890. For instance, the Printers Association in Calcutta, the Kamgar Hidurgi Sangh in Bombay in 1910, and the Amalgamated Society of Railway Servants of India and Burma, they registered under the Companies Act, and they had their own bylaws set out by them. And this is how the momentum took place. In the meantime, the war declared in 1994 gave further momentum to the labour movement in India, because the entire economic situation was changed at the time due to war. Imports of commodities were terribly hit, and there was no availability of cotton, salt, cloth and kerosene oil, etc. It was not available. The cost of living went up, but the capitalists were making huge profit and the workers were not getting even the minimum salary what they are supposed to get. So this actually gave big momentum to the trade movement in India. In fact, the Buckingham Karnataka Mills in Chennai, they staged a strike, in fact, to see that their demands are met, Actually, this is the first movement in South India. However, what happened on account of the agitation, on account of the strike, service conditions little improved. However, they needed proper guidance and leadership. Then Madras Union was the first train of union of modern type in India. The progress was mostly because of the spirit and sacrifice by President Mr. B.P. Wadia at that time. By 1920, large number of unions were formed. Then All India Trade Congress was formed, and it represented workers' interest in economic, social and political wherever and whenever it became necessary. Then foundation of ATC marked the first recognition of common interest of labour throughout the country. By 1995, number of trade unions increased. During that period, labour movement was hardly united and there was complete harmony and cooperation among all sections of working class at that time. Then, on account of all these factors, the Trade Union Act was brought into force from 1st June 1927. This act, when they promulgated, this greatly enhanced the status of trade unions in the workers' imagination and in the public minds. This gave a lot of momentum and status to the working class. The Trade Union Act 1926 covers mainly three sets of matters. One is that the condition governing the registration of trade unions and the obligation to which the union is subjected to after registration, the rights and privileges accorded to the registered unions. However, this act did not provide a mechanism to accord status of recognition of a union by the employer in case of multiple unions in an industry, or for that matter, even in case of a single unit in a single union in an industry. It imposed no obligation on the employer to recognize and to deal with such recognized union. In fact, this issue was taken up by the Royal Commission on Labour in India, and also pleaded for recognition of trade union by employers in spirit as well as in letter. Actually, this prominently figured in various agendas. For instance, the Labour Ministers meeting in 1940 and 41, then meeting of Standing Labour Committee in 1944, then Indian Labour Conference in 1945. Actually, on account of all these deliberations, for the first time, the act was, an attempt was made to amend the act to confer status or to accord recognition of trade unions by the employers so that it becomes very effective. But actually, the amendment was very good in terms of it met all the requirements of the trade union what they were asking. But unfortunately, what happened? This amendment was not brought into force at all. It remained on the paper in 1947 itself. Another attempt was made in the year 1950, but again it has not taken off. Hence, the question still remains even today even today, we don't have a legal provision as to how they accord recognition by the employers. It is not all mandated. Now, this is the one problem we are having even till today. This is the question. Now, when coming to the other thing, the office bearers. Who are the office bearers in the members of the executive committee? Actually, the office bearer in the union includes member of executive but does not include an auditor. That's what it says. But when you read with the election rules of a trade union, the office bearers are mentioned as president, vice president, treasurer, secretary, and assistant secretary. Here we may note that various designations like legal advisor to union is not recognized under this act at all because he is not classified as an office bearer. This is one. Now here, if you see the definition under the Trade Union Act, the definition of trade dispute, it requires a lot of interpretations. The trade dispute means any dispute between employees and workmen, workmen and workmen, employees and employers, connected to the employment or non-employment, in terms of employment and conditions of labor of any person and workmen, means all persons employed in trade industry, whether not in employment or the employee with whom the trade dispute. Now, this is the definition. Now, let us try to analyze the definition thoroughly. To start with, the trade union definition is a combination, temporary or permanent, formed primarily for the purpose of regulating the relations between the workmen and the employers, and also to ensure proper service, imposing proper service conditions, monitoring proper service conditions, and to take care of any problems related to the workers and the employer. Now let us have a look at the definition of trade dispute, try to analyze it. If you see the definition, following two factors emerge very clearly. One is workmen and another is trade or industry. It comes there. Now, Article 19(1) of the Constitution provides guaranteed freedom in the sense that every individual has got guaranteed freedom of speech and expression, then assemble peacefully without arms, form association or unions, move freely throughout the territory of India, reside and settle in any part of the territory of India, practice any profession or carry any trade profession or business. This is the guaranteed under the fundamental rights. Now, this article actually bestows upon any citizen of India to form an association or unions. From the article, you can derive that any workman employed has a right to form an association in a manner. Here the point of reference is that, point to be noted is that the workman. Workman means any person employed irrespective of his or her level. In other words, the employer, there is no status attached to a workman. Workman means a person employed. He can be an officer or a non-officer or a manager, whoever it is. He is a person because it is a fundamental right of anybody. So workman has got, workman means it's a large implication of people. It includes everybody. No classifications are done. Now here, the questions are that, what about the army? What about the defense forces? What about the police forces? What about the fire extinguishers, fire brigades? And what about the police? Can they form a trade union and fight for? This question arises. For this purpose, the Article 19(1), it says they are not absolute. Article 19(2), the fundamental rights can be reasonably restricted by the state or central government by various legislations to curb the formation of union in the interest of sovereignty or integrity of nation, security of state, friendly relations with foreign states, public order, decency, morality, contempt of court, defamation, incitement of offence, etc. For these reasons, the central or state government can formulate appropriate legislations to see that this right is not permitted for these categories of people. Now, for that purpose, armed forces, defense or military workshops, military canteens, police force, home guards, fire brigades, and judiciary, they are not given this kind of a fundamental right as given to other people. Hence, they cannot form any trade unions. Supreme Court has held very clearly in the case of Delhi Police versus Union of India in 1987 that any restrictions on 1912 is constitutionally valid, and further held that the Delhi Police cannot form a trade union. Similar case came up in the Tamil Nadu NGO versus Registrar of Trade Union in 1962, where here what happened was that the NGOs who basically the members are the sub-magistrate in judiciary and tahsildars. So the court said no, they cannot, because the people engaged in foreign legal functions in the state where they have got their alienable functions, so they cannot form a trade union. Now this is the concept of the limitations of trade union, how it can be even in spite of the fundamental right, because there is an exception under the article, they can restrict it. Now we should understand the business of trade and industry. Now when we discuss this trade or industry in the chapter of industrial disputes, we have discussed elaborately as to what is an industry on account of the interpretation by the Supreme Court in the case of BWD versus Rajappa. We discussed thoroughly in this chapter. Same thing here also is applicable. In other words, any systematic activity organized with cooperation between the employer and employees for the purpose of production or distribution of goods or service is squarely falls under industry. So here there is no exception at all. Wherever the employee relationship subsists, automatically falls under the category of industry, and trade unions can be formed after that without any exception. Even for instance, in the case of Tirumala Devasthanams, there are contentions saying that the temple took a contention saying that the trade union, they did not want the employees to form a trade union. They took a contention saying that we are not an industry. But the AP High Court has said very clearly in 1917 itself, saying that because the Devasthanam is also engaging in other activities like supply of power, water and maintenance of quarters and employing people, hence it is an industry. Hence, since it falls in industry, trade union can be formed by them, it is approved, and the trade union is recognized by them. So in the case of GTRS versus Office Association in Bangalore, they also said that the definition of workman have very wide scope. It means that the officers are entitled to become, they can form an association because the definition of workman is quite wide enough. So from these definition selected, we can see that the definition of trade or industry has got a very, very wide meaning, and it covers wide coverage. Now, mode of recognition is a very, very simple thing. Right from beginning it is there. It means that any 7 members of a trade union, only 7 members of a trade union, by subscribing the names to the rules of the trade union, they can always form a trade union without any exception. So, the process of mode of registration will be very easy. With 7 people subscribing, they can form a union. The only the thing is that Section 6 stipulates that such trade union need to form a bylaw of their own, covering all the following matters. It is the name of the trade union, the object of the trade union, the whole purpose for which the general funds can be used, maintenance of list of members, and adequate facility inspect members by trade union, membership of ordinary members, membership of honorary members, then names of members and executive committee of the union, the method of election. This is how the election, the process of election, and the safe custody of funds, distribution of funds, and all related matters has to be incorporated in the form of a bylaw with these parameters. Once they form a bylaw of this and then go with 7 members who are working in the industry as members of the union, and submit the papers to the registrar of trade unions, the registrations will take place. Now, the cancellation of registration also is possible if the registrar finds satisfied that the certificate has been obtained by fraud or mistake, that the union has ceased to exist or willfully or give after notice contrary any provisions of the Act, he can always cancel the registration. Of course, before cancelling the registration, it is absolutely necessary for the registrar to inquire into the matter by giving show cause notice and further investigation, and then only he can pass the order, otherwise he cannot do it. In fact, there are many cases which support this contention. In the case of Tata Electric Officers Association, Officers Guild was registered in 1994, there is a very clearly cancellation of registration must be contribution must be willful, and after 2 months of notice to be given to the union, then only it can be done, otherwise it cannot be. So here also in case of Tamil Nadu Government Press Workers Sangam in 2004, it has been told that the show cause notice must be served not less than 2 months to the union, and by opportunity of an opportunity should be given to the party, and then only pass the order of cancellation of the union. Again, in the case of Coromandel Cement Factory, cancellation of union registration without giving show cause notice and without giving opportunity to present the case is liable to be set aside. So, in all the cases, the principle is very clear that the show cause notice has to be given by the registrar of trade unions in case he proposed to cancel the registration of trade union. Now, the moment the trade union is registered under this Act, then it becomes a corporate body, because it is statutorily it becomes a corporate body. It means that this union can acquire movable and immovable properties, and it can go by inheritance also, it can go, and it can be sued and can be sued also, both. It means that it is a corporate body. Now here certain acts will not apply to registered trade unions. That is, Societies Registration Act will not apply, then Cooperative Society Act will not apply, and Companies Act will not apply, shall not be registered trade union, because registered trade unions, register of any union under these acts are not trade unions under the Trade Union Act. Hence, nobody can, these registrations are not applicable to the unions. Then Section 15 also stipulates the objects on which the general funds may be spent. For instance, it can be payment of salaries and alliance expenses to office bearers, prosecution expenses and defense of legal proceedings, the conduct of dispute on behalf of trade union or any member thereof, then compensation to member arising out of trade disputes, then allowances and dependence on account of any welfare facility for its members in case of death, old age, sickness, etc. Then they can also they take insurance policies for the members against sickness, accident, etc. Then provision for education, social and religious benefits for the members, and upkeep of periodical journals. For all these objects, the general funds can be spent. The spending should be within the parameters of this Section 15. The register can also constitute a separate fund for what you call civic and political interests of the members. It means that they can form a separate fund, separate constitute fund for political and social purposes for this. They got an authority on this. Now the most important thing here is Section 17, that is the criminal conspiracy in trade unions. Here it gives a blanket provision. It is that no office bearer of a member shall be liable for punishment under Section 2 of 120 of the Indian Penal Code in respect of any agreement made between the members for the purpose of furthering such object to the union as is specified in Section 15, unless the agreement is an aggravator to commit an offence. This is what it says. I will just explain to you in detail. Now here, the law says very clearly that the office bearers cannot be prosecuted in a criminal case for conspiracy if it is in furtherance of an act which is not punishable by under any law. It means that, see, there are two types of conspiracies can happen. In case the conspiracy is to commit an offence not punishable, then there is immunity. In case the conspiracy is to commit an offence punishable, then there is no immunity. I will just give the illustration to explain this. Now let us take the example of one scenario. Let us say the workers want to go on strike. They decide that we should go on strike. Then what they do is they call a general body meeting and they pass a resolution to that extent, and they give a notice of strike to the employer, 14 days notice or whatever to be given. And then after notice is given, after expiry of the notice period, go on strike. But the strike they go is absolutely legal in the sense that they don't come in the way of committing any criminal acts and come in the way of the fundamental rights of the employer, because the employer also has got fundamental right to run the business. He's got a right to his entry into the premises, in ingress and egress, and the movement of materials, dispatch of goods, everything is the fundamental right for an employer. If the union resorts that we will do the strike in a very peaceful way, then what happens? The conspiracy arising out of this is not punishable. Naturally, people have to sit and conspire. The executive committee will sit and conspire. Yes, we will go on strike, but we will give notice. The strike will be a peaceful one. We will all adopt all constitutional methods of pursuing the dispute. Then we will go to conciliation, etc. All these things, if they do it, if they conspire in these fashions, then what happens? These offences are not punishable, hence they get the immunity. So this is the scenario. The second scenario could be opposite side. Suppose they want to go on strike. They say right from without giving notice, tomorrow onwards we will go on strike. And also they conspire. We will not allow the officers to go inside. We will stop them. Not only stop them, if necessary, we will assault them. We will resort into violence. We will stop at any circumstances. We will stop officers to go inside. Or they say, okay, we will hear out the officers. We will not allow them to go. Or we will say that we will resort to violence if it comes to that. And we will say we will resort to all stoppage of movement of materials. If they conspire for all these activities, then what happens? Because all the acts are punishable under the Indian Penal Code. Then what happens? The office bearers will not get the immunity under this section. So they get the immunity if the conspiracy is not punishable, the act is not punishable under law. But the acts, if they are punishable under law, the example I give you, then what happens is that they will not get the immunity and they can be prosecuted under the criminal proceeding. This is one thing available. And the second, before I go to the next, I will just tell this. Do the trade unions have a right to go on strike? Of course, this also we deliberated when we discussed the Industrial Distributors Act. The trade unions do not have a fundamental right to go on strike, but it is only a legal right to go on strike. That's all. In fact, there has been in 1935 itself, in the case of Royker versus Emperor, this principle was enunciated in 1935 itself, to say that there is no constitutional validity. The workers cannot, they don't have any legal right to, fundamental right to go on strike, but only they have got a legal right, provided they follow all the process of law. Now similarly, Section 18 also gives immunity from civil suits in such cases. Here also similar situation like what we discussed in Section 17, that is immunity against criminal conspiracy. Here also the same thing. Here also they will get the immunity of civil suit provided they act in accordance with the provisions of law. It means, in other words, they will not trespass into the rights of the employer in any manner. If that is so, then civil suit will not lie against them. But if they try to do it or they make an attempt to do it, then what happens? They are not immune and civil suit still survives, and injunctions and other leaves can be sought by the employer on the union of his parents. This is a very common phenomenon what we see in whatever day-to-day industrial relations issues. We come across a lot of cases where the trade unions resort to stoppage of materials and the movement of words, stopping people or even threatening people. Even loyal workers, they threaten and they become stand out. Under those circumstances, the employer can go to civil court and obtain an injunction against these people. That immunity is not available for the union because they resort to all these activities which is not approved in law. So for instance, in Madras High Court, in the case of Avtech, they said that Superintendent of Police others, Madras High Court has very clearly said the employer is entitled to police protection in case of strike, obstructions and preventing ingress and egress of men and materials. Though the employees have got right to strike, but they don't have right to resort to all violent and disorderly means of getting the result done. Similarly, in case of Simple Goose versus Amco batteries in Karnataka High Court, physical interference of duress with free movement of executives and contract staff, suppliers, etc. cannot be justified as a trade union right or fundamental right. Section 18 does not afford immunity as an act deliberate trespass, does not enjoy immunity under Section 18. So these are some of the cases which reiterates what I explained to you under Section 18 under scenarios. Similarly, in case of Selvagans, Principal High Court in Madras Rane 2012, here also the Madras High Court held that trade union and house bearers were charged with misconduct post law, unleashing spate of violence incidents both within and outside the establishment on frequent site, not adhering to agreed forms, norms under the settlement. Disputes of the whole inquiry held the house bearers and trade unions have no privilege from misconducts. And in the case of Rotas Industries Staff Union versus State of Bihar, held that employers also do not have the right to claim damages against the employee who participated in illegal strike. Here what happened, on account of this strike, the employer suffered naturally the business loss. And he filed a case against the office bearers. There was an interesting case in this matter. One of the company by name Rohat Industries claimed damages against the employee for participating in illegal strike and thereby causing loss of production and business. And in fact, in this case, the High Court has held that employees do not have right to claim damages against the employee for participating in illegal strike and thereby causing loss because there is no provision like this. This is in the case of Rohat Industries Staff Union versus State of Bihar in 1963 itself. Now, another most important thing is that the union activities at workplace is not permissible. Because the basic philosophy is that an office bearer of a union basically is an employee. He is bound by the terms and conditions of the employer in terms of discipline as well as production. He has to do that. The trade union activities are outside the working hours. It cannot be trespassed into the working hours where he need not get any kind of relief on account of that. In fact, this issue has been taken up in a number of cases in before various courts, and all the courts are held very clearly that union activities are not permissible during working hours at workplaces. In fact, I can say that in the case of Tamil Nadu Industry Board Accounts and Executive Staff Union case in Madras High Court in 1980, Barker versus NTC in Supreme Court decision in 2001. This is a Supreme Court decision actually. Then R.K. Kaul case in state of Madhya Pradesh in Madhya Pradesh High Court, and Karnataka High Court in the case of Uttar Pradesh High Court in the case of Ravindra Sharma. Then AP High Court case in the case of Singarani Collieries, and Karnataka High Court in the case of Madhavan versus management of Sundaram Motors. And there are many cases, of course. I collected only a few cases, but there are many cases have clearly held that the union activities at workplace is not permissible. Similarly, the trade union leaders are not immune for any disciplinary action. Because being a union leader, he may commit misconducts during the working hours or within the premises. Then he is not immune to this thing. He is definitely can be charge sheeted or put an inquiry and even dismissed, provided the actions or provided the misconducts are proved beyond doubt. Similarly, a transfer of employees, in the case of transfer of employees also, the union office bearers cannot get any kind of immunity, because transfer is an incidental function of a management, and in case of exchange of work, the employer has got every liberty to transfer any workman, even including an office bearer of a union. Of course, unless it should not be malified and there should not be any kind of victimization behind this. Otherwise, an employee can be transferred. In the case of Singapore Airlines versus Quentin Rodriguez, Bombay High Court in 2008 had felt very clearly transfer of a union leader from Mumbai to Jalandhar. Even though he has been the union leader for 10 years, he is not immune to such one. Transfer shall take place and he has to go. Similarly, union leader, as I told you already, has no immunity from misconduct, since he is also bound to be disciplined. In case of Usha Branco Madhu Sang versus Usha Branco, year 2009 Supreme Court decision. So it is well settled law. It is well settled in the legal system, saying that if the misconducts are proved beyond doubt, the plea of victimization fails. The union leader might saying that I have been victimized for this, but if the misconducts are proved beyond doubt, the plea of victimization definitely fails. Now, disqualification of office bearers of a union, this is also permissible in case of certain contingencies, in the sense that he has been convicted in a court of law for any offence involving moral turpitude. He can get disqualified from the office bearer of the union. He is not immune to all those things. Then proportion of office bearers to be conducted in the state, now it is one half the executive committee can be the outside members of the union. In case of change in name of the union, must be supported by not less than 2/3 of the total members. Then amalgamation unions is also permitted and it is possible, and of course the 50% of the workers members of the union should approve the amalgamation schemes. Now in the beginning we talked about the recognition of unions. Now this question still arose, and then since the amendment did not take place, and this question still remained in the minds of employers, employees as well as the trade unions. Actually, in spite of the fact that Royal Commission of Labour, first National Labour Commission and second Labour Commission also seriously made recommendation to legalize the recognition of trade unions, but nothing has taken place. But actually what happened was that in the year 1958, in the 16th ILO Convention, the employees and the government, they discussed and drafted a code of discipline. It is a statutory code of discipline, but it is a memorandum code of discipline to be observed by all the people, like the employers and the union and the government shall form this. In this, they built in the concept of recognition of trade unions. They also drafted what are the criteria for recognition of union. They did where there are more than one union, the union claiming the registration must have been functioning at least for 1 year, and he should have a membership of at least 15% of the workers in the establishment, and membership would be counted only if those who paid the subscription at least for 3 months during the period and immediately preceding the month of reckoning. Union may be recognized a representative union for workers on the establishment in an industry in a local area where it is a membership of at least 25% of the workers of that industry in that area. Where the union has recognized, there must be no change in the position at least for 2 years. In other words, what it says is that the majority membership, whichever the union has got majority membership of the union, can be recognized as the recognized body for collective bargaining and other purposes. In short, this is the criteria drafted by and adopted as code of discipline amongst the tripartite body. Now, though this doesn't have any statutory backing, but we can see that even our judiciary has recognized the code of discipline for according recognition to the trade unions. In the case of International Airport Authority, Workers Union International Authority, this question came and reached the High Court recognition. The High Court felt very clearly to say that the majority, the election must be held and majority of the workers shall be recognized. Majority of the union, which has a larger membership, shall be recognized. This is the decision of the Bombay High Court in this particular case. Then similarly, an association of chemical works, Rane versus V.D. Rane and others, Bombay High Court has done the same thing. Here the appellant is a rival union under Chemical and Fibers India Ltd. The industrial court in the order had pointed out that total employees as on 15 June 1981 were 811 and the respondent union had a strength of 448 as against rival union strength of 241, thus observed to be recognized union. So here also, though there is no statutory backing, still the union recognized, the judiciary recognized the code of discipline in the matter of recognition and observed it. Similarly, in the case of Associate Engineering Works, by Supreme Court also has endorsed the same view to see that the majority of the members with the union which has got the majority members as their members shall be recognized for all these purposes. They have been upheld even in case of by Supreme Court also. Similarly, in the case of Supreme Court also has held in the case of General Secretary versus Roorkela Shramik Sangh versus Roorkela Mazdoor Sabha, this dispute arise, where finally the court ordered the Deputy Commissioner to call for records and verify the membership of the union and then give the certificate to the union which has got the larger majority members in its role. In fact, little detail has been showed in the slide. Maybe you can have a glance at it. That will give a fair idea about it. So this is the background and the important features of the Trade Union Act 1926. And now recently we can find that the multiplicity of trade unions in the Indian organization has been a diminishing one. In earlier days, we used to have multiple unions in an organization, but now for the last 10 years, we are seeing that it is fading away, and now only one union for one unit has been the trend nowadays. Nowadays, workers also have realized that multiple unions may pose problems, and probably a culture is being set in slowly that one union, one industry comes. Slowly it is coming. But yet we have to see if any amendments are made by Government of India in the matter of Trade Union Act. Thank you very much.